Hello, and thank you for joining us today. My name is Ed Redder, and I would like to welcome you to today's webinar. I'm a partner in the Employee Benefits Practice Group of Thompson Hine in our Columbus office. I'm fortunate to be joined today by my colleague, David Uhlendorff, also from our Columbus office. Our webinar today is the final in a series of 9 we have presented examining the various aspects of Secure 2.0 and how they impact employers. We will provide a high-level recap of the most important Secure 2.0 provisions, with particular emphasis on the most frequently asked questions by plan sponsors and related open issues. We will also focus on the most recent guidance of Secure 2.0 or otherwise impacting retirement plans in the coming year. To proactively address a frequent question, today's webinar is being recorded and will be sent to all registrants within approximately 2 business days. During the presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer questions at the end of the webinar as time permits. And with that, I will hand the microphone to David, who will begin the presentation.
Thanks, Ed. So as Ed said, our agenda today is kind of threefold. Our first topic is going to be Secure 2.0. Before last week, when we had planned this webinar, our intent was, as Ed said, to kind of provide a brief update on Secure 2.0 topics that were effective in 2023, and then kind of emphasize what topics were most relevant to plan sponsors beginning in 2024, the year ahead. Well, the fortunate for us and all of the listeners here today, the IRS was generous enough to release new guidance on Secure 2.0 relating to long-term part-time. That was on Black Friday of last week. So we will talk about that today, and our discussion today will actually focus on that a little bit more than it otherwise would have. So we'll go through some of the Secure 2.0 recap things pretty quickly today with just an aim to focus on the long-term part-time guidance that we just got. The second part of today's presentation will be on the EPCRS update. It's kind of an extension of Secure 2.0, but just a refresher for plan sponsors to know where we are from a correction perspective. And then finally, we're going to pivot away from Secure 2.0. Looking ahead to the new year, just one of the more important and new topics that we have to discuss. It's the proposed fiduciary rule update. So without further ado, quick 2023 recap for Secure 2.0. As a reminder, this is the final 2023 webinar we have on this topic. So for those who attended the prior webinars this year, this is old news, but just to kind of frame our discussion today, Secure 2.0 was passed at the end of 2022. It's more or less a sequel to Secure 1.0 that was signed into law in December 2019. As far as effective dates, Secure 2.0's provisions, there's kind of a cascade of effective dates. They come in waves. Some of the provisions were effective immediately. Many of them are effective in the coming year, and then we have a group that are effective in 2025 and even beyond. As a quick reminder, the purpose of Secure 2.0 generally was to increase opportunities to participate in employer-sponsored retirement plans. There's a lot of focus on removing perceived barriers to participation for participants, namely access to emergency savings funds, but also to incentivize employers to sponsor retirement plans and easing regulatory burden of sponsoring retirement plans. Again, as a reminder, the plan amendment deadline for Secure 2.0 is not until the end of 2025 generally. Secure 1.0 and CARES Act were also delayed so that they kind of are tied to the Secure 2.0 deadline as well. So we have some time on that. Most of Secure 2.0's provisions impact 401k plans. There's also many provisions that impact 403b plans equally and even pension plans. Our perspective today is going to be kind of primarily from that 401k plan context. A lot of the provisions in Secure 2.0 are optional. Some are mandatory, but many are optional. So we'll try to highlight that as we move kind of quickly through the recap of those provisions. And as I think most people on the call are familiar with at this point, the big challenge here has been implementing some of these provisions, both from a record keeper capability standpoint, but also in kind of, we don't know exactly what a lot of these requirements entail, or there's a lot of open questions that beg for more guidance. And as I said, the IRS was fortunate, or we're fortunate enough that the IRS did release some additional guidance last Friday. We also got some additional guidance on the EPCRS provisions earlier this year. So we would expect more guidance to kind of come out piecemeal from the IRS to better kind of inform our understanding of these provisions and to aid in our implementation of them. So going into the specific provisions, the recap of the specific provisions that were in effect immediately, of course, the required minimum distribution change was a big one, and this was no surprise. We had, or nothing new at least, we had a similar provision in Secure 1.0 that changed the age from 70.5 to 72. Secure 2.0 increased this age to 73 and built in a future increase in 2033 for up to age 75. So to the extent you were not aware, you are now aware that effective for any distribution required to be made after December 31st, 2022, with respect to individuals attaining age 72 after such date. That's the new RMD age. The other topic that was, it's a good transition topic because it really bridges the gap from Secure 1 to Secure 2.0 and bridges the gap in our current year to next year, because we have this long-term part-time concept that comes out of Secure 1.0 that we'll spend some time on here. But the Secure 1.0 is not only effective now and even in 2021 and 2022 as the years that we need to track hours. 2024 is also the year that under Secure 1.0, the long-term part-time employees could first become eligible. So it's kind of our bridge topic as we talk about going from 2023 to 2024, and then we'll focus on those new proposed regs. So, but before we get to the proposed regs, just some background on this requirement. And even before getting to the long-term part-time change, some just background on how employers have discretion to define eligibility and the requirements that eligibility criteria are subject to. So generally, employers have the discretion to define who's eligible to participate in the 401k plan. There are minimum coverage requirements that have to be satisfied under 410B, of course. But for example, eligibility can be based on classifications, salary versus hourly is example provided here, but any kind of business criteria, location, facility, you're going to be able to make eligibility decisions based on those types of criteria. The classification cannot impose a service-based classification in excess of what we refer to as the minimum age and service requirements. We've lived with these minimum age and service requirements for a long time, and that's the age 21 and 1 year, 1,000 hours of service. That's kind of always been the rule, and that's, you know, now it's going to be layered a little bit with the long-term part-time requirement that we'll talk about in a few minutes. And then there's a note here, the plan must specify the entry date as of which an employee is an eligible employee who satisfies the age and service requirements to become eligible. So we have the satisfaction of these minimum age and service requirements, but then we also have this concept of an entry date. It could be immediate, it could be the first of the month, it could be a quarter, and you know, that's when the eligible employee would begin participation. So 401k plans have historically been designed to, or permitted to be designed to apply different age and service requirements to different classes of employees. Like I said, you know, you could have a full-time employee that's eligible to participate immediately. Part-time employees would have to satisfy that 1 year, up to that 1 year, 1,000 hours of service before becoming eligible to participate. But you can also design your 401k plan to have different service requirements to different types of contributions. For example, you could have no service requirement for deferral purposes, but you impose a 1 year, 1,000 hour requirement before the participant can make or receive matching contributions. So just some background on kind of the structure that we've worked with. Then Secure 1.0 came in. It added this second layer of this minimum age and service requirement, essentially. Instead of the 1 year, 1,000 hours, Secure 1.0 says if you have a long-term part-time employee, and it defines that as an employee who over 3 years achieves at least 500 hours of service, well, then you have to let them into the plan for purposes of making deferrals. At least deferrals. There's no requirement that we allow long-term part-time employees to receive those matching contributions or any other type of employer contributions, but they have to get in for deferral purposes. And for Secure 1.0 purposes, only years of service that commenced on or after 21 were counted. So anything pre-21 would be excluded for purposes of calculating those hours. Secure 1.0 also had this concept of excluding long-term part-time employees from certain compliance testing, minimum coverage testing, your non-discrimination testing, and then top-heavy requirements. And then lastly, Secure 1.0, or this long-term part-time employee specifically, did not apply to collectively bargained participants. So then we had Secure 2.0 come down, and the next couple slides kind of just compare the two. Really the big change from Secure 1 to Secure 2 is this shortening of that measurement period from 3 years, in which they would have to be credited with at least 500 hours of service, to 2 years. So starting 1/1/25, meaning if an employee gets 500 hours in 23 or 24, and 24, excuse me, then they would be eligible for 2025. So what didn't change? The plans can still apply an age requirement. The plan's entry rule dates would still apply, and then the definition of a service period for purpose of determining year of service would still apply. So really, we were able to kind of understand that plans that generally permitted all employees to participate, that didn't apply this 1,000 hours in a year requirement, were generally not going to be impacted. Similar to the elapsed time, using elapsed time, although we'll touch on that a little bit more because our understanding of that has evolved a little bit with these proposed regs. But that's really it from our Secure 1.0 and Secure 2.0 pre-proposed regs perspective.
Excellent, thanks, David. So as David mentioned, the IRS gifted us, or Treasury gifted us, proposed regulations covering long-term part-time employees. Mind you, this is coming nearly 4 years after Secure 1.0 was adopted or signed into law. But so now we finally have some additional guidance that helps us kind of flesh out some of the requirements for long-term part-time employees. And I have to say, at a very high level, there weren't any real significant surprises in my mind. A lot of helpful clarifications and addressing, a number of open questions I think the practitioners have had, since Secure 1.0 and Secure 2.0 were adopted into law. And so it was published last Friday, right? It was first issued last Friday, published in the Federal Register on Monday, 11/27. And so if finalized, the proposed regs would amend 1.401K-5 of the regulations, effective for plan years beginning on or after January 1st, 2024. And the proposed regs clarify that taxpayers can rely on the proposed regs pending issuance of final regs. We have a 60-day comment period that is open right now, and there's a public hearing scheduled for March 15th of 2024. So let's talk a little bit about the regulations. And so just again, stepping back for a minute, these regulations impose requirements as do Secure 1.0 and 2.0 for qualification of a cash or deferred arrangement. And so to be a qualified cash or deferred arrangement, among other things, we have to meet certain participation and vesting requirements for employees that are considered long-term part-time employees. And so that gets us into kind of the core of the regulation, which is the definition of a long-term part-time employee for this purpose. And as we anticipated, the regulations confirm that a long-term part-time employee includes an employee eligible solely by reason of having completed the applicable 12-month period, either 3 years or 2 years, depending on the plan years, right, with a dichotomy of Secure 1.0 and 2.0, and have attained age 21 by the close of the last applicable 12-month period. It specifically excludes employees covered by a CBA and non-resident aliens with no U.S. source income. So so what this does is it clarifies, right? Again, you have to be eligible solely by reason of meeting the definition of a long-term part-time employee. So if a plan imposes lesser service requirements on employees or provides for immediate eligibility, then those employees are not long-term part-time employees. Regulations also clarify that, if we prospectively amend the plan to add a long-term part-time service requirement, we can't have it retroactively affect employees that became eligible under a different service requirement. One of the open questions, I think, among practitioners was, whether, this would apply or somebody could be a long-term part-time employee if we used some alternative service crediting method. And the proposed regulations make it clear that you can't, if you use the elapsed time method for crediting service, you're not a long-term part-time employee. And that really goes back to kind of the solely language, right? In order to be a long-term part-time employee, you have to be eligible solely as a result of being credited with the requisite hours during 3 or 2 years of service. So again, would not apply to folks that have to meet an elapsed time requirement. Now, it's different though if we're talking about hours credited using an equivalency method. Those are permitted and are consistent with long-term part-time employees, but there's no reduction of hours credited for folks who are long-term part-time employees. So one of the examples in the regulation or the proposed regulation is, okay, well, if you use a monthly equivalency and you have to credit somebody who works at least an hour in a month with 190 hours of service, then you're going to very quickly surpass that 500 hours, right? If you have somebody employed for at least 3 months. And so again, we have this clarification that the use of the equivalency method could still result in long-term part-time employees, but again, elapsed time does not. And please remember, any equivalency method that we use must be set forth in the plan document. So the regulations then kind of move on and address kind of the participation requirement. So we have clarity. We can use the entry date rules in the plan, or the entry date rules in the plan apply to long-term part-time employees. So an individual who's a long-term part-time employee would need to be eligible no later than the earlier of first day of the first plan year beginning after the date the long-term part-time employee satisfies the requirements, or a date 6 months after the date on which they satisfy the requirements, whichever is earlier. So we have clarification there. We also have clarification on the determination of 12-month periods. So we know that the 12-month periods must be consecutive. Prior periods with 500 or more hours are not taken into account if fewer than 500 hours is credited in a subsequent period before satisfying the consecutive year requirement, right? So in other words, I'm credited with 600 hours 1 year, the next year I'm credited with 400 hours, and then the subsequent year I'm credited with 700 hours. Well, those aren't consecutive years. We haven't met the requirement to be eligible as a long-term part-time employee. The break in service rules don't apply for long-term part-time eligibility once the individual or the long-term part-time requirements are satisfied, though no vesting credit would be required for 12-month periods in which at least 500 hours are not credited. 12-month periods, and again, this is consistent with past guidance, 12-month periods prior to January 1st, 2021 are not considered for long-term part-time determinations and cannot be considered for those determinations. The initial 12-month period must be based on date of hire, but the proposed regulations confirm that we can switch thereafter and use subsequent periods that are based on the plan year, and specifically recognize that, okay, we may have overlapping periods and some of the hours may be double counted, right? If we start, say we hired on July 1st, we're credited with 500 hours in that first year, then we start up in a calendar year plan and credit from January through December, we could pretty quickly meet the 2-year requirement.
Yeah, and I think that last point was one of the more interesting things to me from the proposed regs. And I know you and I have had this conversation before the proposed regs were released. There was this reference in Secure 2.0 to the kind of the 1 year, 1,000 hour requirement, and which works the same way. It's based on your initial date of hire, but if you don't satisfy it within the first 12 months, the plan can switch you to the plan year and calculate it that way. But there's this fundamental difference that for the prior minimum major service requirement, you only had to do it once. So there was no question of, well, what if I satisfied in my first 12 months and the first full plan year that I'm a participant, and the proposed regs are very clear. Well, we're going to treat those as consecutive 12 months periods. So for Secure 1.0, it's very possible that I become a long-term part-time in less than 3 years, calendar years. And for Secure 2.0, eligible as a long-term part-time in less than 2 years, again, depending on the plan's administration.
No, that's a great point, David. One of the other key kind of open questions I think that folks have wrestled with over the last several years is, whether this kind of takes away a plan sponsor's ability to design a plan to exclude certain groups. And the proposed regulations did provide some level of comfort, though just a little bit of comfort, to say that they don't preclude a plan from establishing other conditions that are not based on agent service. However, as with the current guidance, and as I think we've interpreted the requirements over time, they can't be a condition, they can't be a proxy for imposing an age or service requirement that exceeds 1 year of service or 1,000 hours, or the long-term part-time service requirement. And I would say there are a number of examples in the regulations, the proposed regulations. They don't get into any real exciting areas that we've debated over time: temporary employees, interns, and some other classifications where there have been some question about whether those are permissible exclusions or not. But at least we have the comfort that the proposed regs are not intended to preclude application of other conditions which are not based on age or service. For example, it would not be permissible to require temporary employees to be credited with more than either 1 year of service or 1,000 hours, or 1,000 hours in a year of service, or long-term part-time service requirements. However, it doesn't explicitly address the blanket exclusion of temporary employees. So I think there still are some open questions. There still are some interpretive issues that we need to wrestle with, but at least we have the comfort that these new requirements were not intended to modify kind of the past practice on this.
Yeah, and to me, this was a classic good news, bad news situation where the good news was there's nothing in the proposed regs that seem to indicate they're changing their view on how we've always looked at this issue. The bad news, of course, is that we don't get any more clarity on some of these questions that have always been kind of been asked and somewhat unanswered. But it makes somewhat logical sense, right? The way they phrased this, that we'll know it when we see it, that your requirement is imposing is a proxy for imposing an age of service requirement. So if you could you exclude a temporary employee categorically? Maybe, but if we look at it and we find out that you have temporary employees that are really there for a long time and they're working more than the 500 hours for over 2 years or 3 years, and more than 1,000 hours in a year of service, well, then maybe we do think that it's imposing some kind of unspoken age or service requirement.
Yeah, I think that one of the examples of the regulations talked about a hypothetical employer that had 2 divisions, and the plan allowed certain employees of one of the divisions to participate. To be in that division, you had to be a full-time employee. They defined a full-time employee as somebody that's credited with 1,000 hours in a 1 year period. And so the IRS took the position, well, no, even if you said only participants of division 1 can participate, we're excluding folks in Division 2, it's still an indirect imposition of the age and service requirements, and so it would be problematic to exclude those other folks, even if they met the long-term part-time employee requirements. Vesting. Vesting is obviously an important issue, and we now get confirmation that each 12-month period with 500 or more hours would count as a year of service for vesting. But plans may instead apply computation periods applicable to non-long-term part-time employees. So they don't have to be necessarily consistent, but we do have confirmation that if somebody's a long-term part-time employee, or even a former long-term part-time employee, each year that they're credited with at least 500 hours of service would be a year of vesting service for that purpose. And the regulations do introduce this concept of former long-term part-time employees, which are defined as long-term part-time employees who previously satisfied those requirements and are long-term part-time employees, who cease to be long-term part-time employees by reason of achieving 1,000 hours of service in a year, or eligibility conditions other than age or service exclude them from coverage later on. And so generally, the long-term part-time employee requirements would cease to apply to former long-term part-time employees as of the first plan year following the plan year in which the earlier of satisfying one of those two requirements occurs. So in other words, right, if we're a long-term part-time employee and then we subsequently are credited with at least 1,000 hours in a computation period, then we become a former long-term part-time employee. Or let's say we move to a division that's excluded in the plan from coverage, and so we're no longer eligible under conditions other than age or service under the plan. We'd be a former long-term part-time employee. And what does that mean? So for a former long-term part-time employee, kind of the exclusion that we're going to talk about in a minute from testing would no longer apply to the former long-term part-time employee. Though long-term part-time vesting rules would continue to apply to former long-term part-time employees. And there are situations, right, where you can go from a long-term part-time employee to a former long-term part-time employee back to a long-term part-time employee, right? So for instance, in my example where the person moved to a division that wasn't covered, well, if they move back to a covered division and haven't met the 1,000-hour requirement otherwise, they would return to be a long-term part-time employee. So it's interesting conceptually, but it really is this kind of the switch that tells us which of the obligations and options are available under the long-term part-time employee regulations.
Yeah, and somewhat of an interesting result, that last bullet where you have a long-term part-time becoming a former long-term part-time, and yet they're still benefiting from the long-term part-time status by only having to work 500 hours to get the same vesting credit that another non-long-term part-time is required to hit the 1,000 hours. So just an interesting result that plans will have to keep track of.
Yeah, thank you, David. And as David mentioned earlier, when talking about kind of the background of Secure 1.0 and 2.0, we know that we're generally, or employers are generally not required to be to make non-elective or matching contributions to long-term part-time employees. Now, remember, if you become a former long-term part-time employee, then all bets are off. If you otherwise meet the requirements to participate, right, then you could be required to receive non-elective or matching contributions, though I suppose the plan could be drafted in a way to only grant those types of contributions to certain groups if it passes testing. Safe harbor plans may also exclude on the same basis as non-safe harbor plans. And then we have coordination with employer elections for testing, right? So we may exclude or either exclude or not exclude long-term part-time employees from non-elective and matching contributions. But an employer must make elections in order to exclude long-term part-time employees from testing requirements. it's not automatic. For a non-safe harbor plan, the plan has to include enabling language, and the employer has to make an election to exclude long-term part-time employees from testing. Safe harbor plans that must actually reflect the exclusion of long-term part-time employees from testing in the plan document. And there can be separate elections for coverage and non-discrimination. So we're talking about ADP, ACP, 401A4, and the coverage testing, and for top heavy, but we can't really pick and choose to exclude long-term part-time employees inconsistently for coverage and non-discrimination testing purposes. And we have what I think is an important confirmation that plans may make additional employer contributions and still elect to exclude long-term part-time employees from testing. And for safe harbor plans, those contributions would not be safe harbor. So, one would think, okay, if we're not going to make these contributions, we'd exclude them, but we can really take divergent paths on this, allow folks to receive certain employer contributions, but still exclude them from testing. A few other clarifications. So a long-term part-time employee can be catch-up eligible, though the universal availability requirement would be disregarded if the employer elects to exclude long-term part-time employees from coverage and non-discrimination testing. Similarly, long-term part-time employees can be Roth eligible, but may be excluded from 401A4 requirements if so elected, if there's a desire to exclude them from Roth, right? Because again, if we exclude them from the testing, benefits, rights, and features testing is under 401A4, and so we could decide to do that. There was actually a question posed on the Form 5500 audit requirement regarding whether long-term part-time employees can be excluded for purposes of the audit requirement threshold. And Treasury essentially said, this is outside of our purview. This is a DOL issue, not for us to decide, and so declined to address because it's within the scope of the DOL's authority. Though they did point out, which I think is important, that the Form 5500 instructions provide that only participants with an account balance are counted for purposes of the small plan audit waiver. I guess with the thought that a lot of long-term part-time employees, given the low threshold for admission, may be in a group that is less likely to contribute to the plan. And therefore, if they don't have an account balance, they're not going to count towards that threshold anyhow. So we did a quick blast through the long-term part-time proposed regulations. We're still digesting that, and we'll be back later with additional comments. But I think right now, if we had a to-do list, again, we should be reviewing our current plan design, and we should identify changes that may be required or desirable. Does the plan apply a service requirement? If it doesn't, or if it uses an elapsed time method, then there's really not much to do in this area. If you do, and we may have long-term part-time employees, will the plan exclude long-term part-time employees from employer contributions and or coverage and non-discrimination and top-heavy requirements? I think it's important to gather data about the number of current part-time employees and estimated numbers who will become eligible to make 401k contributions under the new standard, because again, right, we're up against the wall right now. We could have folks eligible as soon as January 1st, 2024, based on Secure 1.0, and then 2025 based on Secure 2.0. So if folks out there have not focused on this issue to date, it's really kind of imperative to focus on it now. It'll require some coordination efforts with your record keepers and the HRIS, and we'll have to communicate changes to employees. So again, that's a quick roundup of the new proposed rule. More to come later, and we'll see how it's finalized, hopefully next year.
Right, so moving on to our other Secure 2.0 topics. These have all been discussed at prior webinars, and you have access to those slides hopefully, and to this slide as well, so we'll not spend much time on these at all. But just as a reminder, in 2023, we also had these provisions become effective. The kind of optional small financial incentive for participation, hardship distribution, self-certification, optional treatment of employer match or non-elective contributions as Roth, which is an interesting one, but not sure we've seen much take up on it. Just again, going back to that challenge of administration. Annual reminder notice for unenrolled participants, exemption from a 10% early withdrawal penalty for terminally ill participant, and then special distributions for federally declared disasters. So that covers 2023, and I know a lot of the long-term part-time is also forward-looking, given that they could become eligible in 2024. But we also wanted to spend some time just talking about the Secure 2.0 provisions that we were focused on in the last several months as 2024 approaches. The big one this year, and had so many conversations earlier this year on this topic, the Roth catch-up contributions for high earners. Any participant whose FICA wages were greater than $145,000 in the prior year, any catch-up contributions they would make would have to be designated as Roth contributions. Thankfully, given some of the challenges that record keepers were having to implement this and a lot of the open questions around it, the IRS announced earlier this year that it's a non-enforcement policy until 2026. So that gives us some time to kind of reset and figure out how to administer this, and it gives the IRS some more time to give us hopefully some additional information. The provisions that are definitely becoming effective in 2024, I think it's kind of, these are the big three. The first one being the $7,000 small cash out. So we've had this ability to force involuntary distributions on small accounts. That was defined as $5,000 or less. Anything less than $1,000 could be cashed out. Anything between would have to be rolled over. Well, now that $5,000 is increased to $7,000. I think pretty widespread. That's been an adopted change, or about to be an adopted change, just given that it cleans out some of those smaller accounts, usually term vested participants, that can cause those missing participant challenges down the road. The next one is the elimination of pre-death RMDs for Roth amounts. This was actually always the rule for IRAs, but essentially we're changing how we're going to calculate required minimum distributions by removing Roth from the equation. Makes sense, right? The RMD rules are there so the IRS can get their tax revenue back from those deferred amounts. Roth are not deferred, that you pay the tax before they go in. So the IRS is not really motivated to include those in RMD calculations. This and the next one are both really record keeper issues. To the extent your record keeper has not communicated these changes to you, that's something, a discussion to have, in particular because a lot of the RMD paperwork that's going out to participants will need to be updated, right? Similarly, mostly a record keeper issue, but the surviving spouse RMD elections. Surviving spouses, spouse beneficiaries can now irrevocably elect to be treated as the deceased participant for RMD purposes. The thought being that, given certain assumptions in age, they may benefit from a smaller RMD if they're to kind of step in the shoes of the participant rather than kind of be judged on their own. So again, a record keeper issue primarily, but something that if you haven't had a conversation with your record keeper, it's something that you should be aware of and have those conversations to make sure participant communications reflect these new requirements. A couple grab bag items for 2024. I won't talk in detail about this just given time, but the matching student loan repayment does become effective in 2024. Not wildly popular yet, I think, but we have seen some take up, and it'll be interesting to see how that is administered going forward. But I think it's largely a knowing your participant base and whether this is something that is attractive to your employee base or not. Emergency savings accounts was the other one that I think is an interesting concept. Not a lot of take up because of the challenges that come with administration, but this would essentially just create this savings account within your 401k that you could withdraw from as needed. Again, haven't seen really any take up on this yet, but it's something that I'm sure we'll see more of once we get additional guidance and record keepers are able to catch up to how to get their technology in line to administer something like this. And then just a couple more, just so you're aware, the early distribution for emergency personal expense, early distribution for domestic abuse victims, both of those would not be subject to the 10% early withdrawal. penalty. DOL lost and found database is kind of an interesting one. We are supposed to get guidance, I think, by the end of 2024 that will shed light on what that'll look like, but essentially the DOL's attempt to take a little of the burden off of plan sponsors as far as the missing participant issue by creating this database that will connect term vested participants to their benefit. And there will be a reporting requirement from plans as well, just to keep that, give the database essentially the information it needs. And then increased disclosure on annual funding notices. There we go. There's a DB plan item, and that'll be for 2024. So the annual funding notice that will be issued in 2025 for the 2024 plan year will look a little bit different. Lastly, some 2025 and beyond, just so keep these in the back of your mind as we move forward. That Roth catch-up will be coming back in 2026, like we mentioned earlier. So that'll be something that we kind of monitor. Also, increased catch-up contributions, paper statements. There's some requirements around making sure that this would apply to DC and DB, although the timing, I think, the frequency is a little bit different. But it's kind of a backlash to all the electronic disclosure that we've been permitted recently. And then the plan amendment deadline is that 2025 plan year. So more to come, and I'm sure this will not be the last time you hear us talk about Secure 2.0.
Yeah, David, just to jump in quickly. Yeah, so we've talked about a lot of new requirements and also a lot of optional provisions that can be added. So just in your experience with clients this year, has there been a lot of take up of provisions other than obviously what's mandated under Secure 2.0?
No, I would say the vast majority is really the first three that we talked about for 2024, that $7,000 cash out, and then kind of the changes to calculations for RMD relating to Roth, and then the spousal election. But I've heard of other people's clients taking advantage of some of these other optional provisions, but I think 90% of plans out there are more of a wait and see approach.
Yeah, that's been my experience as well. I think with the pretty significant absence of guidance, other than just a few items that we've seen. Thank goodness for the delay on the Rothification of catch-up contributions. But yeah, it seems that people are taking a wait and see approach until there's more clarity on a lot of items.
So we're moving on from Secure 2.0, but not really, because our EPCRS update is really just an extension, like I said, of Secure 2.0 changes to how we correct our retirement plan errors. So a lot of this will be a refresh, but it's worthwhile given that errors are something that as retirement plan administrators and sponsors we kind of frequently deal with. So just as a reminder, the Employee Plans Compliance Resolution System, EPCRS, it provides these three different lanes for correcting plan errors. You have your VCP program. That was your traditional way of correcting. There's a fee. You have to kind of apply to the IRS, and you agree upon a correction, and you kind of get a statement from them that says, we bless this, and you move on. But there are costs associated with that. Self-correction program, that's kind of where we want to be, and we've seen gradual expansion of how to get into self-correction or those errors that are eligible for self-correction over the past several years, and then even more so with Secure 2.0. And then we have our audit closing agreement program, audit cap. That's where we don't want to be. That's when errors are discovered on audit, and then our options to correct are quite limited, and there may be financial penalties associated. But Secure 2.0, they expanded this kind of self-correction concept even further. Now self-correction is, the period for self-correction is indefinite and has no last day for an inadvertent ineligible failure, unless the IRS identifies the failure prior to any actions that demonstrate a specific commitment to implement a self-correction, or the plan sponsors fails to self-correct within a reasonable period after identifying the failure. Subsequent guidance we received from the IRS earlier this year, I think during the summer, maybe in June, explained that that's generally going to be 18 months, but quite a change, right? We used to have this concept of this significant versus insignificant, which I think we talked about here, and depending on if it was significant, we had a certain time period, maybe 2 years after, maybe 3 years after the error occurred. that's all really gone, at least from a entry to self-correction standpoint. There are some instances where the insignificant or significant analysis still matters, but it's quite the expansion to say now we have an indefinite period to correct, as long as we have taken action to correct before the IRS finds it, and that once we find the error, that 18-month clock starts ticking. There's also these other requirements that are kind of caveats to that general rule. You have to have established practice and procedures, formal or informal. The self-correction is still not available for egregious errors, diversion or misuse of plan assets, or abuse of tax avoidance. And the how we correct is not really changed, right? We still have to correct these issues in the general accordance with the general principles and guidance that we have under EPCRS. So, when we say EPCRS update, I'm sure we'll have a new EPCRS update when we get a Rev Proc. We still have 2021-20, and that doesn't kind of reflect this inadvertent eligible failure concept. But I think in the meantime, we're still operating under the same principles, and I would expect the next Rev Proc to look quite similar, except for kind of the entry to self-correction program. Those terms have changed, but not the correction methodology itself. Secure 2.0 also expanded to include loan errors in self-correction, but EPCRS specifically, it says that you still have to follow EPCRS provisions to correct these loan errors. You just can do it through self-correction, and it makes clear that the DOL is required to or instructed to observe that self-correction as a valid form of correction, but that doesn't keep them from their reporting or procedural requirements, such as if a loan error results in a prohibited transaction and you have to correct that with the DOL through VFCP. The other big change to EPCRS and Secure 2.0 was overpayments. Overpayments have always been a problem, particularly in DB plans, but does occur in DC plans as well. The new rule under Secure 2.0 is that plan fiduciaries are no longer required to seek recovery of overpayments, with a couple caveats. For a DB plan, you're not required to seek recovery except when the failure to do so would materially affect the ability to pay benefits. So you think about the funding of your pension plan. If you're not going to be able to pay other benefits essentially because of a funding issue because of an overpayment, then you're going to have to seek recovery. And for DC plans, you're not required to seek recovery provided that any impermissible forfeitures are restored. So you can think of a profit sharing contribution that was a flat dollar amount, which is not super common, but basically if the overpayment to one participant results in an underpayment to another, then yeah, you're going to have to seek recovery of overpayment either by getting that back or by the plan sponsor making the plan whole. And then there's this generally applicable caveat that says unless the overpayment is the result of fiduciary breach, but the exception to the exception is provided that a breach will not arise if the plan has established prudent procedures. So again, the emphasis on procedures and processes continue to kind of be a plan's best defense in these kind of issues. Another big helpful change was that the overpayment is treated now as an eligible rollover distribution. So under a 401k plan, for example, if someone took money after you made too much of a matching contribution, you discovered after they take a distribution, we used to have to go tell them and say that was not an eligible rollover. Well, now we don't have to do that. They can kind of take it and we can leave them alone. We don't have to go get it. So just kind of eases the burden of a plan administrator for sure. This does not mean that a plan can't go after overpayments. We still can, but the ability to do so has been pretty significantly curbed. There are significant limitations unless the participant is determined to be culpable. So for example, when plans are not allowed to add interest or additional costs, you can't try to recoup something that occurred at more than 3 years before. You can't collect a overpayment to a participant from their beneficiary, things of that nature. There are others. Again, unless you're determined to be culpable. This concept of culpability is kind of still somewhat of a question mark, but the subsequent guidance we received earlier this year gave us a little bit more information. Being culpable really means that the individual bears responsibility for the overpayment, such as through misrepresentations or omissions that led to the overpayment, or the individual knew that the benefit payment or payments were materially in excess of the correct So again, this EPCRS update is really just to remind you that things have changed and things that the way we used to correct things or maybe your options to self-correction are expanded. If you have errors, involve counsel so you can kind of make sure that you're utilizing the most efficient mode of correction. So with that, we're going to kind of transition and pivot away from Secure 2.0 with our final 10 minutes. Ed, I think, is going to talk about the proposed fiduciary rule.
Yeah, thanks, David. And yes, as for folks who have tuned into each of our past presentations on Secure 2.0, you're probably thankful that we're pivoting away from Secure 2.0, even if just briefly, to cover a new development. So on Halloween of this year, the Department of Labor issued both a proposed regulation that would redefine who is considered an investment advice fiduciary under ERISA, and also issued some proposed amendments to a number of prohibited transaction exemptions, class exemptions that are out there. Just as a reminder, right, we have kind of our normal or our typical definition of a fiduciary under ERISA, those engaged in plan management and administration, those who have control over planned assets. But really today with this rule, we're focused on the middle category, right? Those who render investment advice for a fee or other compensation with respect to monies or other property of the plan, or who have authority or responsibility to do so. So what we call an investment advice fiduciary under ERISA. And so, you know, prior to, well, actually even present today, we have the Department of Labor's 5-part test that was adopted back in 1975. And despite efforts to change this over time and reinterpret it, we're still dealing with this 5-part test that's been in place since 1975. And so under that test, right, an individual who is not otherwise a fiduciary under a plan would be providing investment advice and be a fiduciary if they render advice to the plan as to the value of securities or other property, or make recommendations as to the advisability of investing in, purchasing, or selling securities or other property on a regular basis pursuant to a mutual agreement, arrangement, or understanding, that the advice will serve as a primary basis for investment decisions with respect to the plan, and that advice will be individualized. As I mentioned just a minute ago, there have been attempts to alter this rule that have faced successful court challenges. So, you know, we started back in, I think, in 2010, 2011 timeframe. The Department of Labor issued a proposed rule and then withdrew it. We had the final fiduciary rule that came into effect in 2016 with some non-enforcement relief. That was struck down or vacated by the 5th Circuit Court of Appeals in 2018. We then had kind of interpretive or sub-regulatory guidance issued that would have modified the Department of Labor's application of certain of the prongs of the 5-part test, and at least portions of that have been successfully challenged in court earlier this year. And so we're kind of, you know, entering the fray once again to try to alter the definition. And so just very quickly, because we just have a few more minutes. The proposed rule again was issued on October 31st. Again, updated the investment advice fiduciary, and according to the Department of Labor, at least according to their publications, it attempts to take aim at junk fees and prevent investment advisors from providing advice that aims to achieve higher costs at reduced returns. And really the preamble focuses on situations in which a retirement investor would have a reasonable expectation that the person providing recommendations or advice is acting in a fiduciary capacity. So that's really the focus of the proposed reg. It really is trying to narrow and focus on those types of situations. And so we have the new proposed reg, which defines a person as an investment advice fiduciary if, one, they provide investment advice or make an investment recommendation to a retirement investor. It's for a fee or other compensation, and it occurs in one of the following contexts. The person directly or indirectly has discretionary authority or control
whether or not pursuant to an agreement or arrangement with respect to purchasing or selling securities or other investment property for the retirement investor. The person directly or indirectly makes investment recommendations to investors on a regular basis as part of their business, under circumstances indicating that the recommendation is based on the particular needs of the or individual circumstances and may be relied upon for investment decisions that are in the retirement investor's best interests, or the person making the recommendations represents or acknowledges that they're acting in a fiduciary capacity. So how does that change the 5-part test? So here are some of the material changes, right? Again, as I mentioned, the focus is really on the reasonable expectation of the retirement investor. The so-called regular basis prong of the current test, focused on the particular relationship, right? Did that advice provider engage with the client on multiple occasions and provide advice on a regular basis? Now the rule really focuses on the provider as part of the business of the provider, as the business of the provider. Did they regularly provide advice on a regular basis to retirement investors? So really kind of shifts the focus. What does this mean? It could mean that the first time this provider engages with a particular participant, they're providing investment advice. So it's not a kind of one free pass, and then you have to have multiple situations or engagements in order for it to meet the regular basis prong. The mutual agreement and primary basis prongs of the 5-part test are modified, again, to focus on the reasonable expectations of the retirement investor based on all facts and circumstances. So really focus on that. So one would focus on how investment providers market themselves, if they call themselves investment advisors or investment managers, or whatever they call themselves. If it feels like, looks like, implies that they're providing investment advice, they're likely to be held to that standard. It also makes clear that written disclaimers are not controlling if they're inconsistent with other oral communications or marketing materials that they provide. So you can't really speak out of both sides of your mouth. If you represent and orally communicate to folks that you're acting in a fiduciary capacity or that you're providing investment advice, you're going to be held to that standard regardless of what your written agreement says. And the biggie, and this is an area where the Department of Labor has pursued over and over again, is that investment advice extends to rollover advice, both to the recommendations regarding the decision to roll over and to the recommendations on how securities or other investment property should be invested following rollover. So this was guidance in the final fiduciary rule. So they want to make clear, the Department of Labor clarifies that, again, general marketing advice or marketing to a potential client is not investment advice. If you're just kind of telling somebody generally the services you provide and that you're great at it and so on and so forth, really not investment advice. But if it's coupled, if you step over the line, you couple it with specific recommendations on investments or transactions, then you're likely to be considered to be providing investment advice. So let's go to the next slide, David. Just want to hit on quickly, there were various amendments to the prohibited transaction class exemptions. Largely what they do is they funnel all investment advice providers who need to rely on an exemption into one of two existing class exemptions, either 2020-02 or 84-24. And they subject investment advice providers to a number of requirements, but at the center of those, or at the heart of those, are compliance with the impartial conduct standards. So you have to meet certain prudence and loyalty requirements, you have to receive no more than reasonable compensation, and you have to avoid making misleading statements regarding the transaction or related matters. Other exemptions that could potentially have applied to this type of advice situation, which we've listed here, will no longer apply to investment advice transactions. And so again, the Department of Labor is really proposing to funnel people into utilization of one of those two existing class exemptions. And by the way, there are certain proposed changes to 2020-02 that kind of enhance certain of the disclosures and other requirements of that prohibited transaction exemption. So more to come. So takeaways very quickly, investment professionals really ought to monitor the developments of the proposed rule and its finalization and take stock of what they're doing currently. Look at your current practices. You may be fine. Maybe have a very simple structure where you are engaged with clients and ERISA plans, and you acknowledge that you provide investment advice and you conduct yourself and receive compensation that's consistent therewith. That's simple. There's not a lot of changes. However, you could have other structures in place where you may need to kind of evaluate what changes are taking place, whether you're providing advice on rollovers that may be captured here, and whether you need to rely on PTE 2020-02 and make changes to compliance. Plan fiduciaries are a little less directly impacted, though they really ought to take stock of whether the plan service providers will be impacted by the changes and how their service providers will comply with the rules. I would anticipate that the rule will be finalized sometime next year, potentially with a non-enforcement policy for some period of time. So I'm sorry we ran short. We're right at 2:01. Have there been any questions?
We have no questions, so I think you can send us home.
Well, very, very good. Well, thank you for attending. Thank you, David, and thanks to all of you for joining us today. As mentioned earlier, we will send today's recorded webinar and slides to all registrants. The mailing will include all the previous webinar presentations as well. So please keep it handy if you need to review certain areas in the future. If we were unable to answer your questions today, please reach out to your Thompson Hine attorney. If you aren't currently a client, please contact me and I will discuss available options to address your needs. Thank you so much for attending and enjoy the rest of your day.